Victor Hale grabbed my daughter's arm in the lobby of St. Michael's Hospital in Toronto on a Wednesday afternoon and told her she was an embarrassment to his family name. Then he straightened his jacket, looked at the security guard who had watched the whole thing, and walked to the elevator like a man who had spent his entire life walking away from things without consequence. My daughter did not call me right away. She called her mother first, which is what she always does, and her mother called me 20 minutes later with the specific steadiness that tells me she is managing something she does not want me to manage badly. My name is James Whitfield. I am 47 years old. I live in Oakville, Ontario, in a house on a quiet street near the lake where the properties back onto the water and the neighbors know each other by sight, if not by name. I am a managing partner at a private investment firm. I have been doing this for 19 years. And before that I spent 8 years as a corporate securities lawyer in Toronto, which gave me a particular relationship with the fine print of agreements that most people sign and never read again. That relationship has defined my career in ways I find difficult to separate from the career itself. My daughter Elise is 31. She is an emergency department nurse at St. Michael's Hospital on Bond Street in Toronto. She has been a nurse for 6 years. She works nights more often than days, and she comes home with a specific kind of quiet that I have learned to read over the years. The quiet of someone who has seen things in a shift that they are not going to describe at dinner because dinner is not the right container for them. She is composed and precise and patient in the way that people who regularly make decisions about other people's survival tend to be composed and precise and patient. She is also my daughter, which means I know her composure is something she built deliberately and not something she was simply born with. Victor Hale is her fiancé's father. Was, I suppose, is the more accurate verb now. His son Brendan had been with Elise for 3 years. Brendan is a good man, 33 years old, a structural engineer with a firm in Mississauga, and the situation he found himself in on that Wednesday was not one he had created and not one he would have chosen. That matters. And I want to be clear about it from the beginning, because what happened in the following 32 days was not about Brendan. The call came at 5:42 in the afternoon. I was at my desk in the King Street office, reviewing a capital allocation report from one of my portfolio holdings when my wife Catherine called. Her voice had the specific tone of someone who has already processed the first wave of something and is now reporting it, which is more alarming to me than the first wave would have been. Elise had an incident at the hospital today, she said. She's fine. She's not hurt. I want you to hear that first. I put down the report. Tell me. Victor Hale came to the hospital. He showed up unannounced, apparently to speak to Elise about something to do with the wedding venue deposit. They disagreed about it in the lobby. He grabbed her arm, firmly enough that she had a mark, and then he told her. Catherine paused, not from emotion but from the specific pause of someone choosing words carefully. He told her that she was not the kind of woman his son should be marrying, and that she was an embarrassment to the Hale family. I looked at my desk for a moment. Where is Elise now? She finished her shift. She's home. Did anyone see it? A security guard was at the desk the whole time. She said he watched everything. I need you to tell her not to do anything tonight, I said. No calls to Victor. No conversation with Brendan about it beyond what she's already had. Tell her I'm going to handle it. Catherine was quiet. James, she said carefully, what does handling it mean in this context? Something methodical, I told her. I'm going to make a call first. I should explain the context, because the context is where the entire story actually lives. 14 years ago, I identified a mid-sized property development and commercial construction company based in Burlington, Ontario called Hale Group Development as an undervalued asset with strong regional fundamentals. Victor Hale had built it from a residential contracting business his father had started in Hamilton into a commercial developer with significant holdings across the Greater Golden Horseshoe, a portfolio in the range of $300 million in active development value at the time I came in. The growth was real. The financials were clean. Victor had a reputation in the Burlington business community as a demanding operator who delivered results, which is the kind of reputation that reads well in due diligence and occasionally signals something less reassuring about the man behind it. My investment was made through my holding company, Whitfield Capital Group, not directly, through an intermediary structure that is standard in silent investment arrangements, the kind that protects operational clarity for the founder and economic participation for the investor, without requiring either party to have a visible relationship with the other. Victor retained full operational control. I received equity participation. The agreement included standard protective provisions that my lawyer at the time, a meticulous woman named Sandra Ng, who had the rare quality of anticipating situations her clients had not yet imagined, insisted on drafting with particular precision. One of those provisions was a conduct clause. The specific language, which I know because I had reviewed the agreement in the spring as part of my annual portfolio audit, read as follows. Conduct by the principal that a reasonable investor would find materially inconsistent with the standards of professional and personal integrity expected of a principal in a company with public institutional relationships, whether or not such conduct results in formal legal proceedings. Sandra had been particular about the phrase, whether or not such conduct results in formal legal proceedings. I had asked her about it at the time. She had said, "You never know what you'll need, and it costs nothing to be specific." She was right. She is usually right. She retired to Victoria 4 years ago, and I still think about her drafting when I read contracts. Victor Hale had never met me. He knew Whitfield Capital Group as a silent investor, a name in a quarterly report, an entity that had been quiet and non-interfering for 14 years and therefore required no particular attention. He did not know my face. He had no reason to connect the managing partner of a private investment firm in Oakville to the emergency department nurse his son was engaged to marry. He had seen a woman in scrubs standing in the lobby of a hospital, someone who worked in a building rather than owned anything in it. And he had responded in the way of a man who had spent a long time sorting people into categories and acting accordingly. I sat at my desk for several minutes after I hung up with Catherine. Then I picked up my phone and called Neil Travers. Neil is my lawyer. He has been my lawyer for 11 years. He works out of a firm on Bay Street with a corner office on the 32nd floor that has a view of Lake Ontario on clear days. He is not a man who uses 2 words when one will do, which means that when he speaks at length I pay close attention. He answered on the 3rd ring. "James, the voice of a man who has a clean desk. I need you to do 2 things, I told him. First, pull the Hale Group Development Investor Agreement from my file and find the conduct clause. Section 11. Second, find out whether there is a security camera in the main lobby of St. Michael's Hospital on Bond Street, and whether that footage is retained, and if so, for how long." A pause. "Is this related to something that happened today?" "Yes." Another pause. "Is Elise all right?" "She's not injured. I need the footage before any standard retention cycle affects it." "I can have someone contact the hospital's administrative and legal office first thing tomorrow morning," Neil said. "Tonight if possible," I told him. "I'd like to know what we're looking at before morning." "I'll see what I can do," he said. "James." A pause. "Is the person in the lobby today someone connected to the Hale file?" I looked out the window at the Toronto skyline in the late afternoon. "I believe so," I said. "Let's confirm it first. I'll call you." I drove to Elise's apartment in the Distillery District that evening. She lives on the 4th floor of a converted building on Trinity Street, with tall windows and exposed brick, and a kitchen she has made functional in the specific way of someone who cooks seriously but quickly. I brought food from the Lebanese place on King Street East that she likes. We sat at her small kitchen table and she told me what had happened. The lobby had been moderately busy, mid-afternoon, the security desk to the right of the main entrance. Victor had walked in without calling ahead, had approached the nursing floor reception and been directed down. He had found Elise near the elevator banks at the front lobby on her way to the cafeteria on her break. He wanted to talk about the venue, Elise said. We'd been going back and forth about the deposit for the Ancaster venue. He wanted to use a place his family has used for events, and he wanted Brendan and I to contribute to the deposit. I'd told Brendan I wasn't comfortable with the arrangement, and apparently Victor decided to come and tell me that himself. And the arm. She looked at the table. He grabbed my arm when I started to walk away, hard enough that it bruised. She said in the same tone she uses when she is describing a patient outcome. Precise. Managed. Then he said what he said and he left. "The security guard at the desk," I said. "Did he intervene?" He started to come around the desk. Victor was already leaving. She looked at me. "Dad, what are you going to do?" "Nothing that will make anything worse for you and Brendan," I told her. She looked at me with the expression she has had since she was about 12 years old, the expression that says she is deciding how much to believe that. "Dad," she said, "he's Brendan's father." "I know," I told her. "What I'm going to do has nothing to do with Brendan." She was quiet for a moment. "Are you going to do something that I'm going to find out about later and not be sure how I feel about?" I picked up my fork. "That's possible," I said honestly. She almost smiled. "Okay," she said. "Okay." Neil called at 10:19 that night. The lobby of St. Michael's on Bond Street had 2 cameras covering the main entrance area and the elevator banks. The hospital's security management confirmed that footage was retained for 30 days. The footage from that afternoon was intact. I thanked him. I sat in my home office with the door closed, the house quiet around me. Catherine had gone to bed. The lake was out there somewhere in the dark past the end of the street. I pulled up the Hale Group Development Investor Agreement on my laptop. I found Section 11. I read it 3 times the way I read things I know I will need to quote precisely. Whether or not such conduct results in formal legal proceedings, Sandra had been very particular about that language. You never know what you'll need, she had said. I closed the laptop. I thought for a while about a man grabbing my daughter's arm in a hospital lobby and telling her she was not good enough, and then straightening his jacket and walking to the elevator with the unhurried confidence of someone who has never once had to account for the damage he leaves behind him. I thought about that confidence, about how long it must take to build it, about how specific the conditions are that allow it to exist. Then I went to bed. I did not sleep immediately. Welcome to Tender Family Revenge. If you're new here, grab a seat and get comfortable. These are accounts about what happens when people who should have known better find out, too late, that they didn't. Drop a comment and subscribe. You're going to want to be here for this. Neil called me the following morning at 7:50. I've watched the footage, he said. Hospital Legal was cooperative once I explained the nature of the request and the potential civil dimensions. And it's clear, he said. Both cameras. The approach, the contact, the conversation, the departure. The grip on her arm is visible and it is not incidental contact. And James, he paused. He looks directly at her when he speaks, and then he turns and walks to the elevator without looking back. I thought about that. Can you describe his expression when he turns to leave? A pause. Satisfied, Neil said. That is the most accurate word I have. That word, satisfied, stayed with me for the next 32 days, in the way that specific details have a way of staying when they clarify something you already knew but hadn't yet named. Tell me about the clause, I said. Come in at 8:30, he said. I've already pulled the file. Neil's office on Bay Street has that view of the lake that I mentioned, and on the morning of October 9th it was one of those clear early autumn mornings when you can see the water properly, the gray-blue of Lake Ontario going flat and wide toward the horizon. I arrived at 8:30. Neil was already at the conference table with the investor agreement printed and tabbed, 2 cups of coffee and a yellow legal pad. He slid the agreement across to me. Tell me how you read Section 11 before I tell you how I read it, he said. Neil does this. It is a good technique. 11 gives me the right to trigger a buyout of my 19% stake if Victor Hale engages in conduct that a reasonable investor would find materially inconsistent with the integrity standards expected of a principal in a company with public institutional relationships, I said. The clause does not require formal legal proceedings. It requires the conduct to be documented and presented and to meet the materiality threshold. Neil nodded. And your argument is that a principal grabbing a woman's arm in a public hospital lobby, telling her she is not good enough for his family, and walking away with a satisfied expression, all of it captured clearly on 2 security cameras, meets that threshold. Yes, I said. I agree, he said. With one condition. He tapped a tabbed page near the back. The trigger requires that the conduct be made known to the relevant parties before the buyout is initiated. Not public disclosure, documentation and notification. We satisfy that with the footage and the trigger notice itself. I looked at the tab. There is something else, I said. Neil looked at me. Hale Group Development has 3 active institutional lending relationships, I said. The Business Development Bank of Canada, a pension fund consortium through OMERS, and a regional credit union syndicate in Hamilton. All 3 have relationship managers who are paid to monitor reputational and conduct risk in their development partners. Neil was quiet for a moment. I am not going to tell you to contact those relationship managers, he said carefully. What I will note is that the footage is a matter of record obtained through proper legal channels. It depicts an event that occurred in a public lobby of a public hospital in the city of Toronto. It exists. Its existence is factual, and if those relationship managers were to become aware of it through a channel that had nothing to do with your office, I said. That, Neil said in the same careful tone, would be a matter entirely outside my knowledge or involvement. I nodded once. File the trigger notice this afternoon. He picked up his pen. I'll have it drafted by noon. I want to explain what 19% of Hale Group Development actually meant in practical terms, because the number matters and I want you to understand what was actually on the table. Over 14 years, the company had grown considerably. Victor had been a capable builder, whatever his personal qualities, and the greater Golden Horseshoe development market had rewarded capable builders through most of that period. My initial investment through Whitfield Capital Group had been $22 million. The buyout formula in my agreement used a standard valuation methodology, a multiple of average annual earnings over the preceding 3 fiscal years applied to my stake percentage. When Neil's financial analyst ran the calculation, the number was $164 million. That was the contractual obligation that Victor Hale's conduct on a Wednesday afternoon in October had activated. Not a penalty, not a punitive measure. The precise contractual consequence of an agreement he had signed 14 years ago and, I would come to learn, had not reviewed in any serious way since. The trigger notice was filed at 2:51 in the afternoon of October 9th. It was delivered by courier to Hale Group Development's head office in Burlington, to their legal counsel of record, and to Victor Hale's personal lawyer, not by email, by courier, with a signed receipt requirement. Neil called me when delivery was confirmed. "It's done," he said. "His legal team will have it within the hour." How long before they call? Given the amount and the nature of the documentation, I would expect contact within 48 hours, he said. They'll want to assess before they formally respond. "Are we open to negotiation on the amount?" I asked. "We are enforcing the clause as written," Neil said. "The amount is the amount." There is a journalist named Patrick Kwan who covers commercial real estate and development finance for a business publication with offices in Toronto and Vancouver. He had broken 2 significant stories about the greater Golden Horseshoe development sector in the previous 18 months and had a reputation, among people I trusted to know such things, for rigorous sourcing standards and careful documentation. I did not contact him directly. I have a former colleague, a woman named Frances, who spent 15 years in business journalism in Toronto before moving to the communications side and who knows Patrick Kwan professionally and trusts his process. I called Frances on the evening of October 9th. "I have something that may interest Patrick Kwan," I told her. "It involves security footage from a public hospital lobby, a conduct clause in a private investment agreement, and a commercial development principal with active institutional lending relationships who may be of interest to editors covering the sector." "Can you tell me who we're talking about?" she asked. "Victor Hale," I said. "Hale Group Development, Burlington." A pause. "I'll pass it along," she said. Patakwan called me the following morning at 8:04. He asked 4 questions before saying anything else: whether I was certain the footage showed what I described, whether it had been obtained legally, whether I had a financial interest in Hale Group Development, whether I understood that my interest would be disclosed in any story he wrote. I answered yes to all 4. "My motivation is transparent," I told him. "I am a major investor in a company whose principal grabbed my daughter's arm in a public hospital and told her she was not worthy of his family. I am exercising the contractual rights that my investor agreement provides. I am not concealing any part of that." Patrick Kwan was quiet for a moment. "Send me the footage and the trigger notice," he said. "I'll contact Hale Group's communications office for a response." The story ran online on October 11th at 6:15 in the morning, early enough that institutional partners reviewing their morning briefings would see it before their first meetings of the day. The headline identified the trigger notice, the conduct clause, and the security footage. It described the incident accurately. It named Whitfield Capital Group as the investor. It did not name me. I read it at my kitchen table. Catherine sat across from me. She had seen it first, and when I came downstairs with coffee, she was looking at her phone with an expression I had to look at carefully to read. "Your name isn't in it," she said. "No, Whitfield Capital Group is named. Not me." "Victor still doesn't know who you are," she said. "Not yet." She set down her phone. "Is Elise going to be upset about this?" I thought about it, honestly. "I don't know," I said. "I think she might be, and I think she'll also understand it." "Those can both be true," Catherine said. "Yes," I said, "they can." I drove to Elise's apartment that morning. I wanted her to hear it from me before she heard it from Brendan, and I knew Brendan would see it, because Brendan's firm had institutional lending connections through the same development sector ecosystem, and someone would flag it to him before noon. She was home. She had worked a night shift and was still in her scrubs when she answered the door. She read the article on her phone while I stood in her kitchen and made tea. When she finished, she set the phone down on the counter and was quiet for a long moment. "He still doesn't know it's you," she said. "No, Brendan is going to be." She stopped, started again. "Brendan is going to need some time with this." I know, Ice. That's between you and Brendan. She looked at me. Dad, $164 million. That's the contractual amount. She shook her head slightly. That's what he grabbed my arm and said those things for. $164 million. He didn't know that's what it would cost, I said. That's the point. She picked up her tea. She looked out the window at the street below for a while. Okay, she said finally. Okay. Victor Hale's lawyer, a man named Douglas Firth, who Neil described afterward as controlled and deliberate, called Neil at 10:42 on the morning of October 11th, 2 hours and 27 minutes after the story ran. Neil told me about it that afternoon. Douglas Firth's opening position was procedural. The conduct clause required formal legal proceedings and none had been initiated. Therefore, the trigger was premature. And you said? I asked. I directed him to the specific language of the clause, which does not use the phrase formal legal proceedings as a prerequisite and which explicitly states whether or not such conduct results in formal legal proceedings. He has read the agreement. He knows that argument is thin. So what's his actual strategy? He filed a formal objection to the trigger notice this afternoon, and his real argument is characterization. His position is that the footage depicts a family disagreement in a semi-public space, and that the characterization of the contact as actionable is an overreach driven by financial motivation. I thought about the word Neil had used that morning. Satisfied. He's seen the footage, I said. His office requested a copy from the hospital's legal department this morning, Neil said. They've seen it, including the expression when he walks away, including that, Neil confirmed. Which is the part that makes their characterization argument difficult to sustain. A man doesn't look satisfied after an accidental moment of contact. Can they drag this past the trigger window? They will try, Neil said. Which is why I filed for emergency injunctive relief this morning to preserve the validity of the notice while the dispute is resolved. When is the hearing? October 22nd, he said. 13 days. If we win the injunction, the 30-day clock keeps running and they either complete the buyout or face a concurrent breach of contract action. And if we don't win, we win the injunction, Neil said in the tone he uses when the analysis is complete and the analysis is clear. The clause language is unambiguous. The footage is unambiguous. The institutional response is quantifiable and documented. We win the injunction. I looked at the lake through my office window. All right, I said. I'll see you on the 22nd. The injunction hearing took place at the ADR Chambers office on Bay Street in Toronto, which is where private equity and investment disputes of this type typically go when the investor agreement specifies arbitration, as mine did. It had the weight of a formal proceeding because both sides had prepared for it as one. Neil brought 2 supporting materials I had not known about until the day before. A financial impact analysis prepared by an independent analyst quantifying the reputational and institutional lending consequences for Hale Group development in the weeks following the October 11th story, and a written declaration from a commercial law professor at Osgoode Hall Law School addressing the standard interpretation of conduct clauses in Canadian private investment agreements. He also brought me. Victor Hale did not attend. Douglas Firth arrived with 2 associates and a financial consultant. For the first time, Victor Hale's lawyer and I were in the same room. I sat on one side of the table. Douglas Firth sat on the other. The arbitrator was a retired Ontario Superior Court judge named Walter McAllister, a man with the specific stillness of someone who has heard every available argument and has long since stopped being surprised by any of them. Before we begin, he said, I want to confirm that both parties have had the opportunity to review all exhibits submitted to this office. Both sides confirmed. Douglas Firth's opening argument was 38 minutes. As Neil had predicted, it was built primarily around characterization. The incident was a private family disagreement. The contact was not assault in any legally meaningful sense. The footage was being interpreted through a lens of financial motivation. He cited comparable cases from Alberta and British Columbia, where conduct clauses had been found to require a higher evidentiary threshold. He was organized and professional and working hard. When he finished, Neil stood. He spoke for 22 minutes. He directed the arbitrator to the specific language of Section 11 on 4 separate occasions. He presented the financial impact analysis. He played the footage on a laptop connected to a screen at the end of the table. The room watched 23 seconds of video. Walter McAllister watched it without expression. Douglas Firth watched it without expression. I watched Douglas Firth. The clause does not require formal proceedings, Neil said when the footage ended. It requires conduct that a reasonable investor would find materially inconsistent with the standards of integrity expected of a principal with institutional relationships. We have offered 3 independent forms of evidence that this standard is met: the footage, the resulting coverage, and the quantified institutional response. The trigger is valid. Walter McAllister looked at Douglas Firth. "Counselor," he said, "your response to the footage." Douglas Firth straightened his notes carefully. "Our position is that the contact was momentary, the context was a private family matter, and the characterization." "The subject of the footage," Walter McAllister said, "turns to leave after the interaction, and his expression is—" He looked at his legal pad. "Satisfied. That is the word I wrote down watching it." A silence. "That is a reasonable description," Douglas Firth said carefully. "It is also not a characterization," anyone added. Walter McAllister said, "It is what is in the footage." He made a note. "We'll take a brief recess." When he came back, he was direct. "The injunction is granted," he said. "The trigger notice retains full validity for the duration of this dispute. The 30-day buyout clock continues to run from the original notice date of October 9th. He looked at both sides of the table. "Counsel, I would encourage a serious review of the clause language before this matter returns to me." Good morning. The complication arrived on October 26th, 4 days after the injunction hearing and 17 days into the 30-day window. Neil called me at 4:17 in the afternoon. "Firth filed a secondary challenge this morning," he said. "His new argument is a restructuring question. Whitfield Capital Group underwent a standard corporate reorganization in 2020 when you brought in the new limited partnership structure. His position is that the trigger rights may not have transferred cleanly to the current entity, and therefore the notice may have been filed by a party that no longer holds the original investor status." I sat very still. "Is there anything to it?" I asked. "There is a technical argument," Neil said. "It is thin, but it is not nothing, and thin arguments that take time to defeat are still time. The 2020 reorganization was a standard restructuring. The investor agreement's assignment clause covers it explicitly, but he's going to require us to document everything, and documentation takes time, and time is what he's buying." "What do we need?" "The 2020 restructuring documents, the assignment records, the limited partnership registration filings, everything that establishes the clean transfer of rights. I have all of it," I said. "Physical copies." "In the filing cabinet in my home office. I need them today," Neil said. I was at his office by 5:30 with a folder containing every document from the 2020 reorganization. This is the kind of documentation that people who take agreements seriously maintain, not because they expect to need them, but because that is simply how they operate. Neil reviewed the documents that evening. The following morning, he filed a response to Firth's secondary challenge. It was 16 pages. It made a simple point. The assignment provision on page 73 of the investor agreement stated explicitly that all rights, obligations, and entitlements transferred automatically to any successor entity in a standard corporate reorganization without requiring consent of the other party. The 2020 restructuring qualified. The documents proved it. Every filing, every registration, every consent form was attached. Douglas Firth withdrew the secondary challenge on October 29th. The 30-day window expired on November 8th. The buyout closed on November 6th, 2 days early, which Neil had pushed for, and which Victor Hale's side had ultimately accepted, rather than face a concurrent breach of contract action on top of everything else. $164 million, transferred by wire from Hale Group Developments, operating and reserve accounts to Whitfield Capital Group at 3:09 in the afternoon on November 6th. I was at my desk in Oakville when the confirmation came through. I called Elise. "It's done," I told her. She was quiet for a moment. "Is it really?" she said. "It's done," I said again. Another pause. "Brendan and I had a long conversation last night," she said, "about his father, about what his father did and what you did and what all of it means. How are you both?" "We're okay," she said. "We're actually okay, which I wasn't sure we would be." A pause. "Brendan said something I want to tell you. He said that his father has been doing things like this his whole life, and nothing has ever had a consequence. He said he's been waiting for something to be a consequence." I sat with that for a moment. "He's a good man," I said. "Brendan, he is," Elise said. "He really is. I have one more thing to tell you before I close this account. There is a scholarship that Elise does not know about. It is administered through the Registered Nurses Association of Ontario. It provides 2 annual bursaries of $6,000 each to nursing students at Ontario universities, who are completing their final year of clinical placement and who can demonstrate both financial need and community involvement. It is funded through a modest endowment established in November of this year, funded by a specific portion of the buyout proceeds. The endowment is structured to run for 30 years at its current payout rate with conservative compounding. At the current distribution rate, the scholarship will support 60 nursing students over its lifetime. The account was established by a philanthropic services firm. It has no traceable connection to Elise and no traceable connection to me. It is named the Bond Street Nursing Bursary, after the street where St. Michael's Hospital stands. The RNAO administers the selection process independently. The first recipients will be announced in the spring. Victor Hale does not know he is funding it. The endowment was established using the proceeds of a check he signed 14 years ago and had not read carefully in years. He cannot stop it. He will pay for it for 30 years automatically by the operation of an investment structure he did not think to review, funding the education of nurses whose work he would never have thought to value, in a hospital lobby where he grabbed a woman's arm and straightened his jacket and walked away satisfied. He does not know the name behind Whitfield Capital Group. He does not know that the investor who held 19% of his company for 14 years is the father of the woman in the lobby. He does not know about the scholarship, and he will not find out through any channel I control. There are things I want to say about what this experience taught me, and I want to say them plainly and not as a rhetorical exercise. Victor Hale walked into a hospital lobby and made a calculation about the woman standing in front of him. He calculated her position, her uniform, the space she occupied. He assessed the geometry of that lobby, and he made a decision about her based on what was visible. And what was visible told him she was someone he could handle without cost. He made that calculation in a fraction of a second, and he did not question it because the calculation had never failed him before. He was not entirely wrong about the visible geometry. Elise was, by the metrics of what a lobby shows you, in a position below his in the conventional mapping of such things. She was in scrubs. He was in a tailored coat. The room looked exactly like what he assumed it was. What he could not have known, because I had spent 14 years being deliberately invisible, was that the most consequential thing in that lobby was not the private care he had come to discuss or the institutional access his money had purchased. It was a 19% stake that had been sitting quietly in his company's capital structure for 14 years, attached to language that a meticulous lawyer had drafted on the specific premise that the person signing the agreement might one day do something a reasonable investor would find unacceptable. Sandra had been very particular about that language. "You never know what you'll need," she had said. The lesson, and I mean this without drama, is about assumptions and the conditions under which they become dangerous. Victor had operated for years on the assumption that his invisible relationships, the silent investors, the dormant clauses, the agreements he hadn't revisited in a decade, were safe precisely because they were invisible, that the people who didn't announce themselves had nothing to announce, that the corridors he moved through with confidence contained no one with a claim on his future that he hadn't already accounted for. He was wrong about that, specifically because his confidence had never required him to check. Unchecked confidence does not make you a villain. It makes you someone who has stopped asking whether the room is what it appears to be, and rooms are very rarely exactly what they appear to be. I am not a man who finds satisfaction in financial confrontation. What I felt through the injunction and the secondary challenge and the buyout closing was not satisfaction. It was something more like the specific quiet completion of something that had needed to be done carefully and had been. Elise will receive the scholarship notifications through professional channels next spring, the way all nurses in the province will. She will not know the source. She may apply to administer the selection committee. I would not be surprised if she did. And Victor Hale will write no check, make no transfer, sign no form. The endowment operates without him. It asks nothing of him. It simply exists, and it will keep existing for 30 years, funded by the proceeds of an agreement he signed when he was a different kind of builder and has not thought about carefully since. There is a particular quality to consequences that are permanent and quiet and entirely outside the reach of the person who caused them. I find that quality appropriate. I find it, if I am honest, more fitting than anything louder would have been. The most important person in any room is not always the one who enters it with the most confidence. Sometimes it is the one who has been quietly, carefully, patiently present for 14 years, waiting for nothing in particular, and prepared for everything.